Hey everybody, welcome to another edition of Polite Society News. This the Legal Friday with Alex Ooley version of Polite Society News. Speaking of which, joining me is, as soon as I get the right button clicked here, Alex Ooley. Alex, thanks for coming on the show today, man.
Yeah, great to be with you, Paul.
We should mention as we get going two things. First of all, Alex is an attorney, but nothing we say on the air should be considered legal advice. And secondly, if you are watching us live on Facebook or YouTube, go ahead and comment on the live video, and we'll get those comments. Any comments that we get that are relevant, we'll get them put on the air and discussed. So let me make sure that everything's turned on, and there we go. All right, let's go ahead and get started, Alex. The biggest news from the last 2 weeks since we've done a Legal Friday edition, the biggest news is Miller v. Bonta that got decided out in California by he's become popularly known as Saint Benitez, Judge Roger Benitez of the Federal District Court in Southern California. Just a brief sketch, the overview, the assault weapons ban that California has, it was declared unconstitutional. Judge Benitez issued a 79-page ruling. I've got some really good quotes that I want to get to in here, but I'm guessing you've at least had a chance to start looking at the ruling?
I did. I finished reading it today, as a matter of fact. So I got to read through all of it, and it's a wonderful read. Most legal opinions are difficult to read and not all that entertaining, but there's a great deal of history in here and facts and statistics, and it's a well documented, well footnoted opinion as well. So it's worth checking out and reading, even if you're not an attorney. You can. It's accessible, certainly, even to non-legal readers.
Yeah, I'm going to try to find a link here. Here we go. I've got a link. I'm going to go ahead and I'm going to put it in the discussion in Facebook and YouTube chat. So if you're watching us live, or even if you're catching the replay, because the replay still gets you can still get comments on the replay. You can check the comment section and get your get your reading pleasure from there. I do have the decision up, but obviously 79 pages and we got 30 minutes. I can't read, let alone comment on it in that time. But so I think where we stand now, and just to briefly synopsize where we're at, this is going to get kicked up. I imagine that if I remember all of my news briefs I've gotten over the past couple of days, this has already been appealed to the full Ninth Circuit. His previous decision a week or so ago immediately got took up by the en banc Ninth Circuit, and this one I think just will go to a 3-judge panel unless something extraordinary happens. What do you think, man?
Yeah, it should. And of course, we would have said the same thing about the Duncan case that you're referring to as well, the Duncan v. Bonta, which was the challenge to the high capacity magazine ban in California. Of course, just referring to standard capacity magazines. But of course, Judge Benitez in the district court there in the Southern District of California issued a 71-page opinion in that case. Of course, it was well written, well documented. There's a lot of overlap between the opinion he issued in Duncan and the opinion he issued this week in the Miller case, because they involve similar types of bans. They're bans on particular types of bearable arms. They're not time, place, manner restrictions. They're restrictions on the type of arm, so that it's a similar analysis, similar historical analysis. So the opinions were very similar, but both worth reading. But like you said, in the Duncan case, the case was appealed to the Ninth Circuit Court of Appeals, which is the intermediate court there in California. And typically the Ninth Circuit would hear the case by a three-judge panel, at least initially, before being heard en banc by a larger panel of judges, an 11-judge panel in the Ninth Circuit. Uh, the Ninth Circuit, though, circumvented that typical traditional process in the Duncan case and skipped the three-judge panel so that they could be sure that the injunction granted by Judge Benitez would be stayed. They were, of course, concerned that if the case went to a three-judge panel, that the injunction would remain in place and that the California law could not be enforced. So they went through a questionable process. Of course, it was allowable, I think, under the rules of the Ninth Circuit, but very unusual to skip the three-judge panel. I'm not sure that it was ever done in the way that it was done in the Duncan case, and heard the case en banc because they said it was a comeback case. And of course, what they meant by that was that this case had been to the Ninth Circuit before. In fact, it was there before the Bruin decision came down and was sent back down to the lower district court after the Bruin decision to be reconsidered and relitigated based on the guidance given by the Supreme Court in Bruin. The Miller case is in a similar position. The Miller case was filed in 2019 and went through the Ninth Circuit and is back down to the lower district court level to be reconsidered based on Bruin. And that's exactly what's gone on here with the decision by Judge Benitez. He's reconsidered the case and issued a new opinion based on the guidance given by the Supreme Court in Bruin with respect to the with respect to the assault weapons ban in California. And I don't know what the Ninth Circuit will do with it exactly. They may surprise us again, but of course it should go to a three-judge panel. The good news is that in this circumstance, there's another case out of the Fourth Circuit, and I think it's referenced in an article that you had queued up today from Bearing Arms, Paul, the Bianchi case out of Maryland, out of the Fourth Circuit. It's an assault weapons ban that has been pending for over a year in the Fourth Circuit. I think it's on a closer path or a closer trajectory to get to the Supreme Court than the Miller case. So the good news is if the Miller case does get sort of stonewalled in the Ninth Circuit for a little while, there's another case in the queue that may reach the Supreme Court sooner.
I want to get to a couple comments here real quick. Robert says, "Don't worry, the Ninth Circuit will mess it up." And yeah, I think your crystal ball there, Robert, is fairly accurate on that count, especially with what we've seen with the previous case going up and the Ninth Circuit sending it directly to an en banc and lifting the restrictions on the state enforcing the law. He also says, "The Third Circuit needs to get their act together and free us here in New Jersey. I can almost smell the freedom." And with what you referred to, the Maryland case in the Fourth Circuit, I think the Supreme Court is going to free New Jersey, so to speak, long before the Third Circuit will.
Yeah, I'd say that there's a good chance of that. It's unfortunate, as Robert points out, that so many people are waiting on the courts to give them back their freedom. And I hope that the courts will eventually, and I think the Supreme Court will, at least in its current composition, will ultimately overturn these assault weapons bans and high-capacity magazine bans, etc. But as you know, and as we've said on this podcast many times, a right delayed is a right denied. And unfortunately, there are lots of folks in that position, including those in New Jersey.
Yeah, I want to get to, I pulled out 3 quotes from Benitez from a couple different articles. first one I want to give is this is from Benitez's writing. California's assault weapon ban takes away from its residents the choice of using an AR 15 type rifle for self defense because it is modern rifles. Is it because modern rifles are used so frequently for crime? No. The United States Department of Justice reports that in the year 2021, in the entire country, 447 people were killed with rifles of all types. From this, one can say that based on a national population of 320 million people, rifles of any kind, including AR 15s, were used in homicides only 0.0000014% of the time. Put differently, if 447 rifles were used to commit 447 homicides, excuse me, and every rifle related homicide involved an AR 15, it would mean that of the approximately 24,400,000 AR 15s of the national stock, less than 0.00001832% were used in homicides. It begs the question, what were the other AR 15 rifle types used for? The only logical answer is that 24,399,553, or 99.999985% of the AR 15s were used for lawful purposes. Not only is the guy thinking the correct way, he can do math.
Yeah, there's some big numbers in this opinion. Many attorneys and judges are scared of numbers, but Judge Benitez didn't shy away from the numbers in this opinion. A lot of attorneys say I became a lawyer because I couldn't do math, but that's certainly not the case here. What I like about Judge Benitez's discussion of the numbers here is that they're not really legally relevant, because what the state of California is doing by bringing up numbers is, of course, trying to engage in interest balancing, right? Where they ask the court to weigh the relative dangerousness of a particular type of arm or weapon and the state's interest in regulating that dangerous item with the individual right to exercise that right or to possess that arm or weapon. And that's exactly what the Supreme Court said we should not do, that interest balancing was done at the time of the founding when the Second Amendment was adopted. But Judge Benitez, I'm glad he includes the numbers here, because although it might not be legally necessary to his opinion, uh, I think it helps convince some of those folks practically speaking, some of those folks on the fence about uh, our right to keep and bear arms and what sorts of arms should be allowed. It may help convince them that maybe these types of arms aren't such a big problem after all, and that these arms are actually used far and wide for lawful purposes by law-abiding people.
Absolutely. Another comment we got in here, similar vein of Robert's comment. Warsaw Patriot says, Paul, I heard about the ruling Benitez made out of California. Soon this will help Illinois State and others. And honestly, it's got to get to the Supreme Court. Either this case or the case out of the Fourth Circuit needs to get to the Supreme Court for it to help in Illinois. Illinois is the Seventh Circuit, I believe, along with Indiana, and there are federal cases for the Illinois assault weapons ban, and there's a couple state cases, but the Ninth Circuit, when they rule, the only thing that it will help with the Seventh Circuit is it can be used for supplementary arguments as to why the Seventh Circuit should rule one way, because the Ninth Circuit ruled similarly. Am I right there?
That's right. Yeah, it's persuasive. So the Ninth Circuit would be persuasive to the Seventh Circuit, but not binding, not controlling in any way. So you're exactly right there, Paul. One thing that's interesting about this opinion, you've read a few quotes from it. It's littered with excellent quotes. and it would be impossible to get through them all in this show. But one thing that it mentions, I think this opinion does a great job at drawing the distinction between or highlighting the distinction between how these types of arms, AR-15s in particular, are used in a horrible way, as they are in mass killings, but then also how they're used in lots of useful life saving ways by people that we never hear about. Everybody hears about the mass killer on the mainstream media and news outlets, but they never hear about the day to day people that use them to protect themselves and their families. And this opinion highlights that contrast early in the opinion. And I like that he includes this contrast and this distinction early. And I'd like to read just a little bit here, if it's okay, Paul.
Absolutely.
He says, people have heard about the Robb Elementary School shooting in Uvalde, Texas. They have heard about Sandy Hook, Parkland, and Pulse nightclub and other tragic mass shootings, but they do not hear of the AR-15 used in Florida by a pregnant wife and mother to defend her family from two armed, hooded, and masked intruders. As soon as the armed intruders entered the back door of her home, they pistol whipped her husband, fractured his eye socket and sinus cavity. Then they grabbed the 11-year-old daughter. The pregnant wife and mother was able to retrieve the family AR-15 from a bedroom and fire, killing one of the attackers while the other fled. It does not require much imagination to think what would have happened next if the woman had lived in California and could not possess such a firearm. And I'm not going to go through all these, but he provides at least two more examples a lot like this. One, an example of an older woman who was living on her own and was attacked on her property in Florida. Or I'm sorry, it was an older man, and another of a young man in Oklahoma. And I think that by including these stories in his opinion, he draws out the impact and sort of the absurdity of the state of California's argument that these are arms that are only used for unlawful and horrible purposes. They're not. They're commonly used by good people every day for lawful purposes.
Absolutely. And lawful purposes, I'm gonna say the one of the best lawful purposes is deterrence, simply because having these things be legal in all but I think 4 or 5 states, and those are the, let's face it, those are 4 or 5 of the most high crime states. If you know breaking into a house, there's a good probability that person behind there is going to have an AR-15 or any other long gun, shotgun or whatever. There's a less likelihood you're going to say that large screen TV is worth my life. I think the deterrence alone is a good enough reason to keep the AR-15 around.
Yeah, and we know this is not a study specifically addressing the AR-15 and the usefulness of the AR-15 for deterrence, but it's, of course, a great example. There have been many studies that suggest that between 500,000 and 3 million times a year, firearms are used for defensive gun use. That means they're not necessarily fired; they're simply used, either displayed or in some other manner used, sometimes without being fired. Many times, most of the time, without being fired. So that's a great example. And to your point too, Paul, or to your example, you mentioned might make somebody think twice before they burglarize a home to get a TV. John Lott makes this distinction. Of course, we talk about John Lott quite frequently. He's, of course, the director of the Crime Prevention Research Center, runs crimeresearch.org, a great website with lots of great information. But he talks about this comparison in burglaries between the United States and the United Kingdom. And I don't remember the exactly what the percentage is, but in the United States, burglaries only between 10 and 20% of burglaries. I know it's less than 20%. between 10 and 20% of burglaries in the United States are in occupied homes. In the United Kingdom, it's over 60%. And it's exactly because of the point that you're making, Paul, because they know in the United Kingdom the person is unlikely to be armed and unable to defend themselves. So um, I think that that's another great statistic that helps draw out the deterrent effect that firearms can have.
Well, and I believe in the United Kingdom, even if you are legally armed, even if you have a legally owned shotgun, which is what most of the legally owned firearms in the United Kingdom are, even if you have a legally owned shotgun and somebody breaks into your home, it's still illegal for you to use that shotgun in self defense. So if you do use that shotgun when somebody's breaking into your home with an axe and other things, you're going to go to jail. So thank goodness we don't live in the United Kingdom. But
Yeah.
I do want to get into, and you were mentioning, one thing that shocked me, I'm going to go back to that last quote. Judge Benitez actually laid out a number of ARs that are owned in the United States, 24,400,000 AR-15s. Given that we don't have an exact number of firearms in the United States because the background where we get numbers from NSSF is the number of background checks that are done every year. They take that from the FBI, extrapolate it, and give out the approximate number of firearms sold. But we don't know how many of those firearms are handguns, are long guns, or whatever. So I'm somewhat surprised that Benitez was able to come up with that number, and that's a very, very big number.
And he mentions that it's more than the most popular truck in the United States, more than there are F-150s on the road in the United States today. So clearly, and of course the point he's getting at is that these clearly meet the definition uh, and are included in the arms that are protected under the Second Amendment because they're arms that are in common use for lawful purposes. And of course, he's pointing to that common use test, which was established in Heller.
Mm. All right, and I want to take just a second. There was a case in the Northeast, and I'm trying to remember, and my memory is just not working that well. I want to say it was New Jersey, where pepper spray was no, I'm sorry, it wasn't pepper spray. It was stun guns that were common use, and the number for stun guns was somewhere around 180,000. That the courts decided that was common use. Yeah.
Yeah, exactly right. And of course, they're both subject to the common use test because we're not just talking about firearms here. I mean, the Second Amendment is the right to keep and bear arms, which include things like stun guns. Those are, of course, arms protected under the Second Amendment and subject to the common use test. And the court, as you say, Paul, held that even those were in common use and only have a small fraction of those in the hands of people nationwide as compared to these so-called assault weapons.
I'm going to get another comment up. This is going to take us a little bit on a left turn, but the AK-47/Kalashnikov is Russian and Europe's major rifle. In America, the Armalite AR-15 is America's rifle. Was, is, and always will be is the rest that doesn't show up because my software cuts it off after a little bit. I do not remember myself whether California or Illinois or Maryland or New York, New Jersey, wherever else. I do not remember if any of those. I know they all ban the AR-15. I don't know if any of them or if all of them as well do ban the AK. I would think so, but
Yeah, that was included in at least here in the California ban, and it was interesting. they went through a list of, I think there were three different types, and I don't have it here right in front of me. I'll get it wrong if I don't look at the statute itself. But it would have included the AK style rifles as well. Um, but of course, these prohibitions, no matter what form they take, are relatively arbitrary. And one point that I can't remember who I heard made this point, but they said one of the arguments that California makes is that, listen, just because we're banning these assault style type rifles, um, we're not infringing on the right to keep and bear arms because they have so many other options. And the absurdity of it's amazing to me that they're willing and brave enough to make that sort of absurd argument, because what if we said that about the First Amendment? Okay, we can ban these books because you have options to read all sorts of other books. I mean, we would never accept that sort of argument. And that's exactly what California is doing here with the assault weapon argument that they're making in the federal courts.
Let's see here. I want to get one more comment in here. Warsaw Patriot says, in Illinois, they even banned the SKS because it uses the same cartridge as any AK rifle. Just because of that, you don't need a whole lot of great logic to ban guns. Matter of fact, you kind of can't have a lot of good logic. I want to get back to one more. What we often hear when we're talking recently since the Bruin decision, what we often hear is the text, history, and tradition quote from Justice Thomas. And that was him laying out, look, if you're going to pass a law about firearms, this is what it's got to do. It's got to qualify it with the text, history, and tradition of United States law dating back from 1791. Writing about that, Benitez says, with nothing else to go on, the state tries to identify a tradition of firearm regulation based on 4 laws that the state claims ban possession of dangerous weapons. Because the law criminalizing the mere possession of a firearm in one's home is kept for self-defense, like California's Assault Weapon Control Act, is so extreme, it would be very important if the state could at least point to a historical tradition of banning the simple possession of any kind of firearm. Unfortunately, the state is unable to find such a tradition. The 4 laws it offers up either did not ban firearms or they did not ban possession. Moreover, the 4 long shot laws came too late in time to establish a new tradition and cannot be used to confirm a non-existent earlier tradition. I do not know the 4 laws that California was using for the example, but it's been said time and again that the laws, the tradition needs to go back to the adoption of the Bill of Rights into the Constitution, which was 1791. Exactly right.
Yeah, and I'll just mention one of the laws, and the one that Judge Benitez says is closest that California relies on is the trap laws, where firearms were set up as traps. Mm-hmm. And he says, while that's the closest analog they can find in the text, history, of tradition regulating firearms, it's not an exact analog or a close enough analog, because it doesn't regulate the type of firearm or the possession of the firearm. It's not a ban on the arm itself. It's a ban on the way the arm is used. You can't set it as a trap. So that's what Judge Benitez said was their best example from the historical tradition, but not sufficient.
All right. So we are coming right down. We've got less than 30 seconds before we hit our 30-minute mark. There was one more story I was going to talk with you about today. We'll have to save that for another time, and we did discuss it briefly on the Wednesday version of Polite Society News when I talked with Mike Piwowarski. So if you're interested, you can go back and listen to that one. But Alex, on our way out, if you would, as I always ask you to do, if you would promote the Forge of Freedom podcast and anything else you want to plug today, man.
Yeah, sure. Thanks for having me on again, Paul. And as you mentioned, I have the Forge of Freedom podcast, which is a podcast I started at the beginning of the year. Of course, I care deeply about the right to keep and bear arms, but I care more broadly about freedom. And the right to keep and bear arms is, of course, a very important component of that, but there's a lot more to it. And my goal with the Forge of Freedom is to provide people with the knowledge and the skills and the attitude they need to preserve and carry on freedom for generations to come. So I hope to inspire people to defend freedom, to care about their freedom, to pass on the knowledge to future generations and the desire to protect it to future generations. So if you would, I'd encourage you to check out Forge of Freedom. It's available on YouTube, Rumble, Facebook, and most of the popular podcast streaming platforms. I'm actually going to be releasing my 70th episode tomorrow about the Ninth Amendment, which I think is often an overlooked component of the Bill of Rights, and explicitly addresses the fact that the Constitution provides and creates a government of specific, limited, and enumerated powers, and that by identifying certain rights as being protected by the Bill of Rights, it doesn't thereby implicitly grant the government the authority to regulate other rights not named. So I think the Ninth Amendment and the 10th Amendment, for that matter, are often overlooked, and I'd encourage you, please go check out the episode that's going to be released tomorrow about the Ninth Amendment. And of course, every Monday, I also have my father on, Mike Ooley, for Monday Gun Day to discuss a firearms-related topic. So if you're interested in that, check it out. Again, that's on YouTube, Rumble, and most popular podcast streaming platforms.
Very cool. Well, that's going to do it for us today. I'm not going to be doing a Sunday show this week. I did not get enough people booked to help with the commentary, so I'm going to set the Sunday show aside this week. I will, however, have one. I think. Let me look at my calendar. Where the heck did that go? Here we are. Yeah, this Sunday I will not be doing a show, but the Sunday after that, the 29th, I can just about guarantee there's going to be a week in review show. So that is going to do it for us today. If you're for podcast viewers, thanks for watching. Podcast listeners, please do consider joining us 7 p.m. Central Time, and every Friday. Alex does Legal Friday every other Friday, and then we do Training Friday every other Friday. Training Friday, of course, with Tom Walls of the Firearms Academy of Seattle. That's it for us today. Thanks again, everybody, and we will see you next time.